Item number 22 deals with marijuana. We want to look at some of the laws and regulations. Our city attorney, assistant city attorney, Chris, is here to give a slide presentation to our residents. So thank you.
Thank you, Honorable Mayor Pro Tem. And I'm going to be speaking about Proposition 64 tonight. Thank you, Honorable Mayor Pro Tem and council members, city manager and staff, and members of the public for all being here. What I'll be discussing is not just Proposition 64, but also a number of other marijuana laws that basically have already gone into effect or in 2018 will go into effect and will affect the city. And this is something that cities all throughout the state of California are dealing with now, or by 2018 they'll be advised to deal with. So as we all know, there's been a lot of changes in marijuana law. And what I'm going to talk about is 9 basic areas. The first one I'm going to talk about is a brief history of marijuana laws, how we got to where we are today, where we're talking about legal marijuana. Second, California's marijuana laws, which is what has legalized cannabis. Personal marijuana cultivation, which is significant in regards to also the commercial businesses. Local control of marijuana, which is what the city council can exercise authority over. The current Carson law, what a lot of other cities are doing in the region, the potential revenue that cities can gain from having marijuana businesses, prohibition options, and regulation options. And before I go into all this, I want to make it clear that I do a lot of marijuana legal advice to cities. I help cities both prosecute illegal dispensaries and cultivation sites. I've done that for years. I've been advising cities more recently on regulating, taxing, and permitting. But I wear both hats, and I can help cities do whatever they want to do while navigating marijuana laws in the context of California's laws. So a brief history of marijuana laws. How did we get to where we are at? It just seemed like yesterday marijuana was illegal everywhere. In 1970, the Federal Controlled Substances Act was passed. That still remains the law of the land. Marijuana is a Schedule I substance under federal law, which means it's prohibited for all uses, including medical. In 1996, however, California became the first state out of 50 to decriminalize medical marijuana, and that was Proposition 215. 2003, California passed, in Sacramento, the legislatures, they passed some new regulations to govern medical marijuana. That was the Medical Marijuana Program Act. It wasn't that successful in regards to local control. We've seen a lot of dispensaries, cultivation sites all throughout the state, and there's been an inability to really regulate or control those. It's largely a function of the MMPA wasn't designed as well as it probably could have been. Interestingly, even though federal law still says marijuana is illegal, in 2013, the Federal Justice Department deprioritized Controlled Substances Act enforcement against medical marijuana in states which regulate. More importantly, in 2014, Congress stripped the federal government of any funds to enforce federal marijuana laws in states that have medical marijuana laws in place. And so right now, today, federal prosecutors cannot prosecute individuals in states that have legal medical marijuana using federal funds. This was upheld in 2015 in a federal district decision, district court. There was a dispensary in Oakland that had been fighting with the city of Oakland for many, many years. And in 2015, the dispensary owners actually brought a motion to the court saying the whole case has to be dismissed because the money being used by the federal prosecutors is illegally being used. The judge had to agree because Congress has prohibited using federal money to enforce the CSA against medical marijuana in states like California. After that case, we came to the current reality right now of the California Medical Marijuana Regulation and Safety Act, which basically builds on Proposition 215, which decriminalized medical marijuana. And I'll get into the important details of that, but basically in 2018, cities are going to see that the state is issuing licenses to commercial medical marijuana businesses, and if cities don't ban those businesses, then that state license will likely be effective to operate in the city. So by 2018, cities need to basically use their local authority or lose it. 2016, as I mentioned, there was that district court case that said money can't be used by federal prosecutors in states with medical marijuana to enforce federal law. In 2016, the Ninth Circuit Court of Appeals, right below the U.S. Supreme Court, agreed and said that, yes, Congress said you can't use money for prosecution, and that's what Congress said. 2016, about two-thirds of Americans now support legalization of marijuana. 2016 also, we saw Proposition 64 passed, which was a big game changer for California. Proposition 64 deals largely with adult use or recreational marijuana. It's no longer something that is just a medical issue, at least as far as the law is concerned. Most significantly, there'll now be licenses available in 2018 for recreational commercial businesses that sell marijuana and do a whole host of other activities. Also in 2016, the election of Donald Trump created a lot of uncertainty on the federal stance towards enforcement of the Controlled Substances Act. I've been doing these presentations for a number of years now, and I used to always say, well, you never know what'll happen in 2016. Perhaps there'll be a new president, unlike President Obama, that will start enforcing federal law. Well, that happened. Trump's been on the fence, but his Attorney General Sessions has said he would like to enforce federal law. Congress isn't providing the funding against medical. Recreational is up in the air right now. You saw in 2017, just recently, Governor Brown in California, at his encouragement, the legislature passed and Governor Brown signed SB 94. This was actually just a month ago that it became law immediately. MAUCRSA, the Medicinal and Adult Use Cannabis Regulation and Safety Act, essentially merged the regulations for medical and recreational into one system. And so there's going to be the same license types. There's going to be the same Bureau of Cannabis Control in Sacramento. There's going to be one code section in state law that governs medical and recreational businesses that sell, cultivate, manufacture, test, or distribute marijuana. So where we are today, 2017, federal law, the CSA, Controlled Substances Act, remains valid. Marijuana, under federal law, completely banned all throughout 50 states. However, a tribute to our federalist system of government, where states, cities, counties can have authority outside of the central government, 29 states and the District of Columbia have legalized medical marijuana. 8 states and District of Columbia have legalized recreational marijuana use. So there is a conflict in federal and state law. As I'd mentioned, it's a little complicated, though, because Congress has stepped in, the courts have stepped in. We don't know what the new president's going to do. And the big issue why we're here tonight, in 2018, January 2018, under Proposition 64 and MRSA, the Medical Marijuana Regulation and Safety Act, there will be state licenses issued from Sacramento for commercial, recreational, and medical businesses. If cities are silent on this, then more than likely, the law is a little unclear, but more than likely, those state licenses will allow folks to operate with them in that city. And so the 450 plus cities all throughout California right now are asking themselves, what are we going to do about those businesses? Are we going to be silent on it? Are we going to ban them all? Or are we going to allow some and regulate them, ban others? It's a question that cities are encouraged to answer, or else they're ceding their local authority to Sacramento. That's a brief history of marijuana law. A few decades of how we got to where we are, where we're talking about how is Carson going to deal with legal marijuana. California's marijuana laws today, right now today, under Prop 64, personal marijuana possession, cultivation, and use is legal statewide. So an individual throughout the state of California can possess up to an ounce of marijuana for any reason. They can grow up to 6 plants at their home, and they also can use marijuana legally, as long as they're an adult. Right now, also, it's legal for nonprofit medical marijuana dispensaries to operate throughout the state. That's all going to change in 2018 when commercial, for-profit marijuana businesses will be legal statewide. Specifically, there'll be 20 different licenses for marijuana medical businesses, the same 20 for marijuana recreational businesses. Most of them are for cultivation. There'll be 14 cultivation types. And then there's going to be testing, manufacturing, distribution, and retail. Interestingly, personal marijuana cultivation is one of the areas in personal marijuana use that cities have some control over. As I mentioned, statewide now you can possess up to an ounce of marijuana for any reason. It doesn't have to be for medical. That is preempted from local control. Sacramento has said, and Prop 64 says you can have up to an ounce, and you can use it. You can cultivate up to 6 plants, but outdoor cultivation can be banned in a city. And indoor cultivation of up to 6 plants can't be banned, but it can be regulated. Now, what does that regulation mean if a city wants to regulate indoor? It's really unclear right now. Prop 64 just says the regulations have to be reasonable. In fact, I put up here on point number 2, second bullet point, all it says in Prop 64, which was written by marijuana advocates, is that cities may enact and enforce reasonable regulations to reasonably regulate indoor cultivation. What does reasonable mean? We don't know. There's one court case already. City of Fontana has been sued over this. But the takeaway from here is that right now, everyone in the state can grow 6 marijuana plants at their personal residence. If a city does nothing and they don't ban cultivation at all, then that individual can grow it outside and inside. Cities can ban it outside and they can regulate it inside. And there's lots of different types of regulations out there on what that indoor regulation would mean. So for personal marijuana cultivation itself, most cities from Santa Ana to San Jose ban outdoor cultivation. Some cities don't bother regulating indoor. They leave it to state regulations to govern what the indoor cultivation of personal marijuana should look like. Other cities are requiring permits to cultivate indoor. Now, like I said, the local regulations must be reasonable. The only guidance we have right now is just you can't effectively ban it by making the regulations so onerous that it's just too hard to grow indoors. What does that mean? The courts will sort it out. We do know in June the first city was sued over their indoor regulations, City of Fontana. At least the lawsuit alleges that a $400 fee and all these different restrictions, like no felony drug convictions, no pending code enforcement actions with the city, etc. The plaintiffs in that case said that's not reasonable. What some cities are doing to kind of split the difference is imposing their own regulations on indoor, requiring a ministerial permit where people just register, but they're not going to have lots of inspections and not have all of these onerous regulations. Other cities are just saying, we'll default to state standards, but we're going to ban outdoor. It's up to Carson what it wants to do on this issue. So we've talked about the history of marijuana laws. We've talked about how in California now, basically limited personal use, cultivation, and possession is legal statewide. We've talked about personal cultivation. There's still some local control. And now we have the big issue of marijuana businesses. So in 2018, we're going to start what's going to be known as a dual licensing regime. Sacramento will issue licenses and permits, and the city has the option of requiring its own local permit or the option of just banning it outright. But if a city does nothing, that state permit will more than likely allow that business operator to locate in a city that's been silent on these different businesses. So cities are urged to take up the question of, are we going to allow any of these businesses or just ban all of them? As I'd mentioned, you can have a local license or you can just ban them. You can have local regulations. You can impose stricter ones than the state standards or default to state. And cities, of course, can tax these operations. So Carson current law, current code prohibits medical marijuana dispensaries. It dates from 2008. And Carson also has 2 marijuana taxes that were approved by the voters in 2016 on cultivation and on operations. What are other cities doing? I've gone through a number of the cities in the LA County region to let you know what they're doing, if they've done anything yet. City of Los Angeles actually was one of the first cities to address medical marijuana back in the 90s.
They were one of the first ones to openly embrace allowing dispensaries. Currently, they have 135 legal dispensaries. By most accounts, there's hundreds of illegal ones in the city of Los Angeles they're trying to crack down upon. In 2017, the voters of LA actually approved regulation of commercial marijuana operations, both medical and recreational, so those will be in Los Angeles in 2018, and local taxation. City of Lomita, they banned all medical commercial marijuana activities. City of Torrance, likewise, they've already instituted a ban. City of Linwood actually is an interesting example of a city splitting the difference, if you will. City of Linwood has basically said they're going to allow all the businesses, but not allow dispensaries. So City of Linwood actually is going to allow up to 5 businesses for medical marijuana cultivation and manufacturing, but dispensaries remain banned. City of Compton, they've had a first reading on prohibiting all commercial marijuana operations and deliveries, and also on medical marijuana dispensaries. City of Norwalk, they basically already prohibited through an urgency ordinance through October 2018 all recreational marijuana operations. City of Bellflower, like Los Angeles and Linwood, they've actually taken proactive action to allow the businesses in their city and to tax them. They're estimating up to $3.4 million in local revenue from taxing the marijuana businesses. City of Long Beach, the voters passed a local ordinance to allow and license medical marijuana operations. Currently, they haven't taken any specific action on recreational. They also have a tax. City of Gardena has banned all commercial marijuana activities through December 2017. And City of Huntington Park has said that they're going to allow 3 medical marijuana dispensaries, but nothing else. So you can see that the majority of cities, at least in the sample in LA County, are prohibiting marijuana activities. And then there's a range of what cities are doing, from the Linwood case of allowing everything but dispensaries. Los Angeles is allowing basically everything, to cities like Huntington Park and Bellflower that are taking kind of a middle road, allowing some but not others. So potential revenue. The city voters of Carson actually approved a marijuana tax ordinance. The estimate at the time, and it's a very loose estimate, was that if marijuana operations were legal in the city, and they're not right now, there would be $500,000 to about $3.5 million in annual revenue. Another potential revenue opportunity for cities is the use of a development agreement for marijuana businesses. Usually this is done with higher-end, long-term developments where there's a lot of land that is being basically developed, and it takes years for the development to occur. Some cities are using development agreements, though, for marijuana cultivation, marijuana manufacturing sites. What's interesting about development agreements is that it's a mechanism to actually secure additional revenue for a city through a contract with the developer. This is still being explored with how well it can be used for marijuana businesses, but some cities are pursuing this. Hollister is one of the cities in the state that has been already implementing this. And then also the other area of revenue is Proposition 64 local return revenue. So there's going to be a statewide tax on marijuana operations because of Prop 64. There's going to be a 15% excise tax on all marijuana activity. There's going to be a tax on cultivation. And some of that money, not a lot in the big picture, but some of that money is going to go back to cities and counties and be used at the local level. That money will not be available if cities prohibit cultivation, including personal cultivation, or retail sales. It's really hard to estimate how much money we're talking about, how soon a city would see this money. Again, Proposition 64 was written by marijuana advocates. The voters of California approved it, and the courts now are going to have to interpret a lot of it. But we do know some money is supposed to go to cities, and you're not eligible for that money if you ban certain marijuana activities. Yes?
Would it be safe to say even if you allow it, because you have to apply for a grant, that you still may not get any?
Yes.
You have to apply for the grant.
Yeah, it's uncertain when or how much money will
Or
be
if at
available.
all.
It's speculative. I mean, it's unclear.
So there's no guarantee. Even there's no guarantee because you have to apply for a grant in order to get some funding.
There's no guarantee. So we've talked about the history of marijuana laws. We've talked about Proposition 64. We've talked about that cities have a decision to make on, before 2018, addressing these state licenses that will be issued. One of the options is prohibition. Cities may prohibit commercial marijuana businesses. They can ban all the businesses if they want to. If that's the intent, then it should be in the local code. One thing to note is that cities cannot prohibit the use of public streets for delivery passing through the city. So if a dispensary in Los Angeles gets an order to go to Long Beach, they can drive through the city. It's just they can't deliver into the city if the city makes that prohibited activity. But you can't prohibit marijuana dispensaries from using the public roads to travel through the city. And you also can't prohibit, as I'd mentioned before, limited personal use, possession, and cultivation of marijuana. So an individual can go to a city where it's legal to purchase marijuana and bring small amounts into a city that bans the businesses. That's just state law now. And yes, individuals can grow 6 plants at their personal residence. And as I'd mentioned, you can ban the outdoor growing and you can regulate the indoor growing, but you can't prohibit it. And that's on the personal level. So if a city doesn't prohibit them all, a city is authorized to adopt stricter regulations in the state. A lot of cities are imposing regulations on top of the state minimum standards and then allowing some of the businesses. The law is crystal clear that you can impose additional regulations. For example, a lot of cities are imposing additional security regulations on dispensaries or marijuana businesses. Some cities are requiring either a quarterly or annual audit of the marijuana business, and they make the business pay for it, which they can do, pass that on. These are some extra regulations cities are doing. As I mentioned before, I've been working with marijuana law now for years. I've helped cities both develop permit and tax ordinances, and I've helped a lot of cities just ban all the businesses too. So whatever the council's pleasure is. And if the city was to regulate a number of issues, and if the city were to have some workshops, then and if there was the issue of what type of regulations the city might be looking at, we could go into these in more detail. But potential regulation issues, one of the first ones is the number of operations. If a city allows dispensaries, you could take the approach of, say, the city of Paris, which just allows as many as can get permits and can find zoning. You could take the example of Palm Springs, which originally allowed 3 medical marijuana dispensaries and now allows up to 6. But the question is how many? And if you limit the number, do you limit by lottery? Do you have discretion where there's some decision maker that picks from eligible applicants? Or do you have a first come, first served? Or as I mentioned, no cap, where market forces determine it. So that's one question if a city's to allow marijuana businesses, the number, and if you limit them, how to limit that number.
Chris,
Yes.
could it be residents only?
Residents only that operate the businesses?
Mm-hmm.
That would be problematic to require only local businesses. There could be encouragement of local business owners. In fact, most cities encourage local business owners, but it would be a restraint on trade to just have a 100% requirement that only residents can operate a certain business.
You could say consideration in cities, not to Carson, will be given to residents.
Yes. In fact,
Especially if they do like a lottery.
yeah, that could be one of the factors the city could look at. As I mentioned, Palm Springs is one of the few cities in Southern California that has had medical marijuana dispensaries in a controlled, regulated environment, unlike City of Los Angeles for a number of years. And they have been having their dispensary applications every time they allow one more eventually go to the city council, and they choose from among different applicants, and then they have written criteria on how the council judges which one gets the permit. Certainly one of the factors could be community involvement.
be getting real.
And isn't there a fee associated with even being permitted to submit your application for a lottery? I thought Santa Ana has something
Yes,
like that.
City Attorney Soltani is mentioning that the city, of course, can charge a fee for the applications that are received. Interestingly, Santa Ana had a very high fee that was charged for applications that the voters approved, basically a tax to turn in an application. Costa Mesa just made the news with charging a $49,000 fee for permit applications that came in. They justified that through a fee resolution that said all that money is going to go to background checks, to inspecting the facilities, to doing audits, etc. But the marijuana industry, interestingly, doesn't seem to be as concerned about fee recovery by cities. So cities have been charging basically every penny that they use to regulate them when they do permit them. Second issue is permissible zones. Obviously, cities can limit them to just industrial zones, which is a lot of cities do, or just commercial. Most cities have a minimum distance from residential zones, schools, and parks. Another regulation is written records. As I mentioned, the city can have audits of the marijuana businesses, and they can make sure that the marijuana business pays for every penny of that audit, pass on the cost. City inspections. Most local ordinances allow for city inspections that can regularly occur. Neighborhood responsibility plan. Sacramento, actually, City of Sacramento, has had one of the most aggressive regulatory marijuana business ordinances that has been out in the last few years to deal with the new regime of Prop 64. And something interesting is for cultivation and manufacturing, they require a neighborhood responsibility plan where basically the applicant has to demonstrate how they're going to mitigate any adverse effects upon the neighborhood, and the city gets to look at that while they're considering if the permit should be issued. I think something equivalent could be used for any of the businesses. Cultivation, if it's allowed commercially, is it only indoor? Is it outdoor? Do you allow both? Safety issues, and then the size of cultivation too. As I mentioned, there's going to be 20 different license types for both recreational and medical. Most of those are for different cultivation types. It goes all the way up to a few acres to just a small commercial grow, and the state's going to be issuing different licenses for those, and the city can pick which ones it's going to allow and then ban the other ones. And then, of course, security, whether or not there's going to be a requirement for guards. Something that most cities require is 24/7 video cameras of all major areas in the business, both entry, exit, where the business operation occurs. They make them keep the video camera tapes for 30, 60, 90 days, and the city has instant access to looking at those tapes if there's any questions about what was going on at the business. So these are all questions that cities ask themselves if they are going to allow any of these businesses. These questions, of course, don't have to be answered if just everything is prohibited. So that is where we're at today. What we're asking the council to provide direction on is whether or not there should be some community workshops to have more involvement of the public. And on top of that, City Attorney's Office and staff recommend that the council, before 2018, consider whether it wants to prohibit and or regulate the 20 different marijuana businesses, commercial, that will be allowed in the new year, 20 recreational and 20 medical. If the city doesn't do anything, it's ceding its local control to Sacramento. So I'd urge the council to consider that question